Hello everyone, welcome to Adamya Academy YouTube classes. Today we will be discussing about the concept of rights and duties. In earlier classes we have discovered about the various schools, analytical school of jurisprudence, historical school and also sociological school. So today we will be discussing concept of rights and duties, and also we will take another school which is the philosophical school of jurisprudence. So let's start without wasting our time. Concept of rights in jurisprudence. The definition of legal rights have been propounded by several famous legal philosophers. Some definitions are as follows. John Austin. According to Austin, a party has a right when another or others are bound or obliged by law to do or forbear towards or in regard of him. So what does Austin has to tell about the concept of legal right? So according to Austin, every party has a right, but does this hold good in today's scenario? Of course not. We will take some examples in which I will state that the definition of Austin does not hold good in present scenario. So let us take the example of capital punishment. So consider a situation in which A has done a grave crime or has done murder or some other person, and in lieu of that he has got capital punishment. B is the person who is the executor of A. So in this case we can't say that A has got the legal right and B has to exercise that right over A, because capital punishment is not a right. So even if B is obliged by law to do an act, it does not make A hold the right. So there are some circumstances or some cases in which capital punishment or the punishments similar to them do not actually brings the right to a certain individual. Rudolf von Herring. Herring defined rights as legally protected interest. The law does not protect all such interests. The interests of men conflict with one another, and the law is the rule of justice and protects only certain interests. So what Rudolf von Herring has to tell? Legally protected interest. What are legally protected interests? Let us consider some situations in which there is not a legally protected interest in the current scenario. So let us take the example of slavery. So do you consider slavery to an offense in the present scenario? Of course, yes, because in earlier times or in the ancient times, slavery was a prominent practice which was being done to show white supremacy over the black persons. But today, this is not the case. So today, slavery is not a legally acceptable right, or it is not a legally protected interest. So in this case, law does not protect all such interests. It only protects the interests which are according to the present society. Let us take the example of such interest. What can be the example of such interest? Example can be right to equality, non-discrimination on the grounds of race, caste, religion, place of birth, etc. So these are the legally protected interests, and law protects such interests. So the key word in the John Austin definition of concept of right is the party has a right, and in Rudolf von Herring definition is that legally protected interests are to be seen. Now let's switch on to John Salmond and what John Salmond has to tell regarding the concept of rights. Salmond defines right as an interest recognized and protected by a rule or justice. He says for an interest to be regarded as a right, it should obtain not merely legal protection but also recognition. So according to Salmond, the right or interest should have some legal recognition or sanction. Let us consider an example, right to opportunity. So does the persons today enjoy the right to opportunity? Of course, yes, because there are many laws and many sections which are written in our Indian Constitution which helps us to get the opportunities which we are seeking in the present society. So the key word here is that Salmon talks about interest recognized and protected. Next philosopher which we will be discussing is Holland. Capacity residing in one man of controlling with the assent and assistance of the state the action of other. This we can understand by an example. Let us consider there are two individuals in a particular society and the individual A have to exercise a right over B. So the individual A is also protected by the state. It means that A cannot do any act with regard to which the state has not given the permission, or he cannot do an act which is in violation of the state made rules. So according to Holland, the one man can control the other man, and also he has to act with regard to the directions which are there given by the state, is what Holland has to tell about the concept of legal rights. Then the fifth proponent is Gray. He defines a legal right as that power which a man has to make a person or persons do or refrain from doing a certain act or certain acts so far as the power arises from society imposing a legal duty upon a person or persons. So what does Gray have to tell? Let us consider an example. Let us consider A has a property worth value of 2 crore rupees. Now, A has bought that property for 2 crore rupees, so therefore A is the owner of that property, and he of course has the title and deeds related to that property, so that no person can trespass to that property and come back and take the property of A. So, Gray has defined it as a legal right, so that another person, let us consider it as B does not have right to come into the property of A without A's permission. So A has the right to do or not to do something with respect to B, and B also has to do certain act and has to refrain from certain acts. This is the definition of concept of right as given by Gray. So the keywords here is referring to do or to refrain from doing certain acts. Essential conditions of legal right. So till now we have studied about the concept of rights which have been given by various proponents. So let us revise what were those proponents' name. First we have seen about John Austin, then we have seen what Rudolf von Herring has to say on the concept of legal right. Then we have seen what Salmon has to tell, and then what Holland has to tell. And at last we have seen what Gray has to tell on the concept of legal right. Now we will be studying about the essential conditions of legal right which are given by Salmon. According to Salmon, there are 5 essential conditions that need to be fulfilled. The person of inheritance or subject of right. He shall be the person who is the owner of the right. He is the subject of legal right. Such a person is called a person of inheritance. Example, Y purchase a van for rupees 20,000. Here Y is the subject matter of right. Let us consider an example in which Y is the owner of the property, and let us assume that Y is not the owner of the property. Instead, Y is the owner of a car and he has to sell that car to A worth rupees 5 lakhs, or let us assume 10 lakhs. So, who is the person of inheritance in this example? In this example, the person of inheritance will be Y, because Y has the right over the property, which in this case is the car. So, you must have understood what is the meaning of the word inheritance, a subject of right. The next essential condition of legal right is the subject of duty, the person of inheritance, incidence. It is the duty of another person or persons to respect and recognize the right of the person. Such a person who has a legal duty is called an incidence. Example, if A has a legal right against B, then it is the duty of B to respect the right of A. So what legal duty does Y have towards A? It's that A has to pay back the money, that is 10 lakh rupees in this case, for buying that car. So the subject matter or the right of subject of duty or the person of incidence in this case is A. So this is what are the essential conditions for a legal right. Contents or subject matter of legal right. The subject matter of legal right is an essential element. It is related to do something or to refrain from doing certain acts or forbearance. It obligates the person to forbear or act in favor of the person possessing a legal right. Example, Y purchase a van for Rs 20,000. Here Y is the subject of the right. So what is the subject of the right? Let us consider the example which I have given you, in which A has transferred or A has sold his car to Y has sold his car to A. So what is the subject matter in this case? The subject matter is the car. So the content or subject matter in this case is car, over which a person is exercising his legal right in lieu of the other person. Now let us look at the fourth essential of legal right, the object of the legal right. The object of the legal rights is a thing or object over which the legal right is exercised. Example, A purchases the car of Rs 1 lakh. Here the car is the object. So what is the object of legal right? Let us consider this case which I have given you. The car is, what is the car? Car is the subject matter of legal right. But do you think that it is necessary that Y should actually have the ownership of that car? It means that Y should not have stolen that car from a third party, or should have taken the car in an inappropriate or illegal manner from other person. So in this case, for Y to be the owner, he should have the deeds or he should have the actual right over that car. So in this case, he should have a deed or paper regard to ownership of car. Is what is the object of the legal right. The fifth essential is the title of the legal right. The title is the process by which the right is vested or conferred on the person. It is certain events by which right is acquired from its previous owner. Example, by purchase of gift or will, etc. So which is the title of legal right? What does it mean? It means that in the example, Y has actually sold his car to A, so the title of the car should actually be given or transferred to A after he completes his obligation, that is, after he pays the full amount of money, and the car should be delivered in an appropriate condition as when it was when they had made the deal with relation to the car. And it is also necessary that the person who is selling that car, in this case the person is Y, should have actual legal right over that car or should be the actual owner of that car. Theories related to legal rights. First is interest theory, developed by Rudolf von Herring, stated that legal right is the legally protected interest. He gave importance to the interest of the people rather than the will of the people. The main objective is to protect the interests of people and to avoid the conflict between individual interests. So now we have studied about the various, what we have studied is what are the essential conditions of legal right, and also what different philosophers or proponents have to tell about in relation to legal rights. Now we will be studying about the theories which are related to legal right. The first is interest theory. What does it mean? The key word here is legally protected interest and individual interest. So let us consider there are group of individuals placed in a society 1, 2 and n. So all these will have different egos and different things on which they might have conflicting interests. So how will they all harmonize with each other, or how will they live peacefully with each other, is the subject which needs, or is the question which needs to be addressed. So to avoid the conflict of interest between these individuals, as well as at the same time we have to take a look that the individual interests are not compromised with. So the two essentials of this definition is that the individual interests of the persons should not be compromised, and also when they are cohabiting at the same situation, then there should be uh, no conflicting interest between them. Will theory. What is the second theory related to legal rights? Supported by Kant, Hegel, Hume, Austin, Pollock, and Holland. According to this theory, rights is an interest, inherent attribute of the human will. The purpose of the law is to permit the expression of free will. The subject matter is derived from the human will. Rights are defined in the terms of will. So will theory also focuses on the concept that what individuals want and what is the will of the individual should be taken into prior consideration and not the general will. So what should be sought is the interest of individuals rather than community interest. So the key word here is free will of individuals. Contents or subject matter of legal right, and all this we have studied previously. Kinds of legal right. So there are different kinds of legal rights which we'll be studying, and there are approximately 24 legal rights grouped into 12 pairs. So 12 pairs legal right. First is right in rem and right in persona. The right in rem is the right available against society at large. For example, a crime committed under IPC because it is a crime committed against the state. So what is right in rem? Let us take an example of IPC. What does IPC contain? IPC contains many laws which are related to crime or the commission of offense. So let us assume that a person in the society has committed a certain crime, let's say theft or murder of the other person. So in this case, will it be considered the crime against the state, or will it be considered the crime against that person? So all the crime is considered to be against the state and not against the individual. So right in rem is the right which is available to an individual in order for him to live peacefully in the society. It means that all the society members should protect the right of A and should not infringe the right of A. So the right available in the society as a whole is what is right in rem. What is right in persona? Right in persona means right that is available against an individual. Example, breach of contract. When there is a breach of contract, the party who has performed the act files the suit against the breaching party. Right in persona is temporary in nature, which can be converted into right in rem. Right in rem is permanent in nature. What does right in persona means? Let us take an example. Contract Act. In a contract, there are two parties, one who is giving an offer and one who is accepting an offer. So the person who there are two parties, and if any of the party does not perform his part of performance, then the other party can enforce that contract in the court of law, is what is written in the Indian Contract Act. So right in persona here means that if there are two parties, let's say A and B, and if A has to deliver certain shipment orders to B on the condition that B has given the money, and B has actually given the money and done his part performance, then it is a duty of A to deliver the shipment orders to B. And this right, if A does not deliver the shipment orders, then B can enforce the right in order to get the shipment orders on A. So this right of B is available only for A and not for the whole society. So B has to enforce that contract from A only and not from the society at large, is what is right in persona. Second is positive rights and negative rights. A positive right is a right when some action needs to be done by the person who has the corresponding duty. The person on whom the duty lies must perform some positive acts. Whereas the negative rights are the rights which omit the person from performing certain acts. Negative rights correspond to negative duty. The person on whom such right is imposed is restrained from performing certain acts. So what is the meaning of positive right and negative right in this case? Let us consider an example. Right to life, right to livelihood. All these are positive rights. It means that there are such actions which has to be done by the person exercising this right. For example, let us consider the right to livelihood. So the person has to actually work or actually has to go into the field in order to get the right to livelihood. Similarly, let us consider a case where there is right in negative sense. So what can be the example for that? Let us consider trespass. So if A has a property, and if let us consider this is the property and A is the owner of the property, and B has come illegally into the A's property without the prior permission of A, then A has the right for not allowing any other party to enter into his premises without his permission. So when not word is used in a certain law or in a certain right, then that right is a negative right, which omit the person from performing certain acts. Personal and proprietary rights. Personal rights are the right to respect the owner of the right. The personal right has no economic value and its right is related to personal status or well-being. Example, the right to live with dignity, the right to freedom of speech and expression. So as the name suggests, everyone has the right to dignity. It means that he or she's reputation should be kept in mind in the society. So this is a kind of emotional right which does not have any monetary benefit. So this is a emotional right. Third is the proprietary right is given in respect of the owner of the property. These rights are rights which have some monetary value or economic value and considered the estate of the person. Example, patent rights, right to lend, debt, etc. So let us consider an example. A has written some books or has written or composed a song in his own wording, and B is the person who actually publishes the song without giving prior information to A. So in this case, the patent right will come into picture because A is the owner of the property and he or she may not allow the other individual to publish the work which he or she has done after so much hard work. Similarly, right to land is also a proprietary right. Perfect and imperfect right. Perfect rights are protected and recognized by law, and the suit can be instituted in court against the wrongdoer for the breach of it. Example: A has taken the loan from B, and B has the duty to pay the loan, and A has the perfect right to claim the loan amount. If B fails to pay, then A has the right to file the suit in the court. So perfect rights are protected and recognized by law. So this is the key word. It means that if A has given a loan to B and B is the customer of the bank, then A should actually transfer the amount, B should actually transfer the amount to A, and both the parties have to do their part of performance in order to have a meaningful contract between them. What is imperfect right? Imperfect rights are those rights which are neither recognized nor protected by law. Example: if the loan becomes time barred, then he can claim his money back, but he cannot be enforced by law. So what are imperfect rights? Some rights are given to individuals by lieu of contract in which they enter, but consider a situation in which A party has to repay the loan to B, which is the bank in this case, but as the loan is time barred, A is not able to pay. So in this condition, it will be considered as imperfect right. Principal and accessory rights. The principal right is the most important right. They are the basic right that is vested on an individual. The accessory right is the consequential or incidental right. They are not important but are ostensible to basic right. So let us consider an example. Right to opportunity. So right to opportunity can be considered as a principal right, and what can be then considered the accessory right to that principal right is that right to get promoted or right to not to face sexual discrimination in the workplace regarding the promotion is what is the accessory right. Then let us consider the next type of right, which is right in re-aliens and right in re proporia. Right in re-alienia is the right available against the property of another person. Example: the right of easement. It is the result of jurisprudence concept of dominant heritage and servant heritage. So right in re-aliena is the right available against the property of another person. It means that if let us consider an example in which A is the owner of this property and B has which is actually the property is located on the second floor of the building, and B has a property which is located on the first floor of building or ground floor. So A, in order to get to the second floor of the building, has to pass through the property of B, which is located on the ground floor. So A has got the easement right over the property of B in this case. So it is the right available against the property of another individual. It means that the property ownership is with A, but the right is available to another individual, which in this case is B. What is the meaning of right in re proporia? It's the right available in respect of one's own property. It results in absolute ownership. So there is a difference between right in re aliens and right in re proporia. Right in re aliens is available against property of another person, whereas right in re proporia is available in respect of one's own property. So what can be the example with regard to this right? There can be many examples with regard to this right. Corporeal and incorporeal rights. Both the rights are protected by law. The corporeal right is the rights over tangible objects or material objects. Corporal rights are having the rights over the objects which can be seen, touched, or perceived. Example, I purchased the watch has physical existence, so I have a corporal right over it. So the meaning of corporal right is that the right exercised on tangible objects. And what is the meaning of tangible object? Tangible objects are the objects which can be touched, which can be perceived by senses around us. So let us consider that I have bought a watch. So the watch, I'm the owner of the watch, and I can do anything with regard to the safety of watch. I can keep it in a cupboard or keep it in a safe place so that no person or anybody in the society causes damage or steals that watch. So this is a corporal right exercised by me over that watch. And then what is the meaning of incorporeal right? The incorporeal right is the right over the object which cannot be seen or touched. Example, right to reputation. We have the right against defamation. It means that anybody in the public cannot defame us or say ill words against us which are not actually correct. Even the politicians or even the persons who have a big name are also protected under this right. Next kind of right is legal and equitable right. Legal rights are protected by the common law, that is Court of England. Common law depends upon usage and custom. Equitable rights are protected by the Equity Court or the Court of Chancellor. So these are two rights which are not available in the present Indian system. What does these rights actually mean? So these rights are far-fetched in the present scenario. Let us take the example of Constitution of India, Indian Penal Code, CRPC, etc. So these all are the legal rights. Because these rights are protected, nobody can go against any section which is written in the Indian Constitution, or let's say for in any other act, and all have to follow what is exactly written in the sections and articles which have been prescribed in the relevant laws. So this is what is legal right. And what does then equitable right mean? Equitable rights are protected by the Equity Court or the Court of Chancellor. The basic principle is natural justice, equity, justice, and good conscience. Equitable rights means that principles of natural justice should be followed, good conscience of individuals should be kept in mind, and fair justice should be given to all the people. So this is what is meant by equitable rights. Primary and sanctionary rights. The primary right is important and is a very basic right. These rights are ipso facto. These rights are independent in nature. It has a binding force. They are right in rem. Example, the right to reputation. If these rights are infringed in such a case, a person can approach the courts of law. A legal remedy is available against such right in the form of compensation or imposing a penalty or punishment. So let us take the example. Consider Article 14 as well as Article 21. So these are the primary rights because these are the very basic rights which are written in the Indian Constitution, and they are the right in rem. It means that anyone in the society cannot actually make another person not to enjoy his right to life. And if a person suffers or if his right is infringed, then then the other party has to give compensation or penalty in lieu of that infringement of the right. Sanctioning rights are resultant rights. These are supporting rights to primary rights. They are right in persona, which results from some wrongdoing. Example, it arises when there is infringement of primary rights. Example we can consider is constitutional remedies. Article 32. So Article 32 comes into place only when the principal right which are the fundamental, which are much placed above in the sequence of fundamental rights, have been violated. So, right to constitutional remedies on Article 32 comes into place in the situations where the basic fundamental rights of the individuals are being violated. Public and private rights. The public right is the right that is exercised by the state. Example, right to vote, right to use road, etc. The private right is exercised by an individual for his personal benefit. Example, right to sleep, right to clean water. So what does public right mean? Public right means that the rights which are given by the government for proper governance of the country, or for providing utility services to the individuals. For example, right to road, right to safe and clean drinking water, right to public parks, etc. are the rights which have been given by the government. So one should not confuse between the right to rem and right in rem and right in persona with right, public right and private rights, because right and rem is available to a person when he is placed in a society against the society at large, and right and rem is the right which is given by the government in exercise of certain rights which the government allows the individual to do. Private right is exercised by individual, right to clean drinking water. Next is vested and contingent rights. A vested right is a right which is vested on the person from the very beginning. No events are required to take place for conferring the rights of individual. It depends on the present situation. It means that the vested rights are the rights which have been given to an individual when he or she has actually got that right, irrespective of the conditions which follow in the course of time. Well, let us take an example. If a child is born in a family, he or she will get the right to the property automatically. So the right to property is vested right in this case. And consider a situation when the child gets married at the age of 18 or probably 21. So when he or she will get married, the right which he or she has in the property may get shifted to other person. So this right is depending on the happening or non-happening of certain event, which is marriage in this case. So this right will be considered as a contingent interest. Now let us go to the next school of law, which is Philosophical School of Jurisprudence. This school is also known as Moral School. This is a very important question because it has been asked previously also that which school is known as the Moral School of Jurisprudence. The answer is Philosophical School of Jurisprudence. The basic aim of this school is that it tries to extract the reasons why which particular law has been established. They basically think that law is a product of human reason and its ultimate aim is to raise and praise human identity. The state and law both are developmental. So what this philosophical school has to tell? I have previously told you that it answers to the question why, how, and when. It means that why the law has come into picture needs to be answered. Similarly, how the law has come and what is the need of that law is what is answered by the philosophical school of jurisprudence. Individual will is harmonized with general will. It investigates the purpose for which the law is created. So this is a very fundamental thought of philosophical school of law, is that individual, along with individual will, general will is also taken into account. So individual will as well as community will is taken into picture while considering any law. Law has to be reasonable and sound for it to be accepted. So the key word here is that philosophical school believes on reasons, that why the law has come, how the law has come, and when the law. So all the questions, WH questions, are being tackled by philosophical school of jurisprudence. The first propounder is Hugo Grotius, which is actually the father of philosophical school. His book is The Law of War and Peace. He contended law as the dictate of right reason, which points out that an act according to it or is not in conformity with rational nature has a quality of moral absence or moral necessity. So what does Hugo Grotius has to tell about law? So he focuses on the right reason or rationality. So the law should be rational in the eyes of people, and any illogical law should not be present in the society, is what Hugo Grotius wants us to tell. The view of him contends that the agreement of mankind concerning certain rules of conduct is an indication that those rules originated in right reason. So, according to him, if we are following any law which is there in the present generation or is in the present society, then of course we know the reason behind that law. We are not following law blindly. So there is some right reason behind it. So therefore, society is accepting that law and following it. Kant. According to him, law is aggregate of the conditions under which the arbitrary will of one individual may be combined with that of another under a general inclusive law of freedom. He believes that a person should act in such a way that maximum of our action could be made maximum of general action. So what does Kant wanted to say? Does he consider individual will to be above general will? He considers that individual will and general will should both harmonize with each other so as to make all the citizens in the society happy, which is written that, and also the individual will of one person should be exercised in such a manner that it gives the freedom to that person to exercise his will, and he is not guided by the sayings of other individuals in the society. So individual may be combined, could be made the maximum of general action. To Kant, compulsion is essential to law, and a right is characterized by power to compel. So what Kant has told in this line is actually very much similar to what analytical school propounders have to tell. They also believe that when a person or when the legislature wants that the law should be followed, there should actually be a compulsion behind following that law. Then only people will think that they should follow that law. He distinguished between legal duties and legal rights, as also between natural right and acquired rights. What Hegel philosophy of law Hegel has to tell? Hegel's book is Philosophy of Law. We have to remember all the books by the various proponents, because these books are actually asked in the multiple choice questions which we have discussed, and which I have told you that in the match of following, these questions come in subsequent years. He says that there can be no dualism of any kind, as any phase of reality is based on a reason. So according to Hegel, individual will and general will should be kept separate. It means that individual will should not be looked into while calculating the general will of individuals. So he did not believe in dualism. He observed that what is reasonable is real and what is real is reasonable. He believed that both state and law are product of evolution of society. So what Kant has to tell is totally different from what Hegel has to tell. So Grotius, Kant, and also the next propounder, Stammer, laid emphasis on individual will plus general will, whereas Hegel is the only propounder which focused on the fact that individual will and general will should be kept separate. So this is what Hegel has to tell. Now next and last philosopher of the day which we will be studying is Stammer. According to him, law is volition, power of will, and is not concerned with the perceptions of external human physical world. He contested that law is just if it conforms to the social ideas of bringing about harmony between the purpose of individual and society, the social idea of community of men willing freely. So he also believes in the general will and also individual will. So individual will should be that there are no conflicts created in the society and the society is able to function peacefully and properly. So he also gives regard to individual will as well as the general will, which is the basic idea of philosophical school of jurisprudence. So this is all what we have studied in today's class. In next class we will be continuing further. Till then, revise and bye.